Welcome to another legal talk on eRadio with myself, Jon, and also Hahn and Hahn attorneys. From the firm today, joining us is Wynand Pieterse to talk about a very hot topic that we often see requests from our listeners called unfair dismissal. What are my rights? Wynand, first of all, welcome.
Thanks, Jon.
Nice to have you back. How's your year been going so far?
Yeah, it's been busy, kicking off with a bang.
Okay, well that's good. Got to keep busy, keeps us out of trouble.
Yes.
Wynand, on today's hot topic, let's just start off first and with an explanation of exactly what is dismissal.
So the termination of an employment contract is not the same as the statutory concept of dismissal. In other words, what legislation says about it. An employee claiming unfair dismissal must establish the existence of a dismissal. If the fact of a dismissal is disputed, it will be the employee who has to prove the existence of such a dismissal. So Section 186(1) of the Labour Relations Act define a dismissal by highlighting 6 elements. These being the termination of an employment by the employer with or without a notice. Secondly, refusal or failure by an employer to renew a fixed-term contract. Refusal to allow an employee to resume work after maternity leave. Selective re-employment, which means that an employer who dismissed a number of employees for the same or similar reasons has offered to re-employ one or more of them, but has refused to re-employ another. Furthermore, constructive dismissal, which means that an employee terminated a contract of employment with or without notice because the employer made continued employment intolerable for the employee. And lastly, the transfer of a business. So what this in essence means is if an employee succeeds in establishing the existence of a dismissal, it means no more than the employee has been dismissed for the purpose of the Labour Relations Act. The existence of a dismissal does not automatically mean that the dismissal was unfair. In the case of dismissal that are not automatically unfair, it generally remains for the employer to establish that the dismissal was effected for a fair reason after following a fair procedure. A dismissal must therefore be both substantially and procedurally fair in order to not make a finding of an unfair dismissal.
Okay, and what forms of termination of employment are not dismissals?
So, Jon, there are a number of common forms of termination of employment that do not fall within the definition of dismissal as contained in the Labour Relations Act. These forms being resignation, secondly, reaching retirement age, termination of a contract of employment by the fluctuation of time or the happening of a specified event, by mutual agreement, insolvency, death, and lastly, supervening impossibility of performance.
Okay, so when would you say is a dismissal actually fair?
So the fairness of dismissal is decided in 2 ways, by substantive and procedural fairness. When referring to substantive fairness, questions to ask is, for example, was there a fair reason to dismiss the employee, and was dismissal appropriate under the circumstances? The employer must have a proper and fair reason for dismissing the employee. A fair reason can be seen as incapacity, like when the employee does not do the job properly or is unable to do the job due to illness or disability. Secondly, misconduct, when the employee has done something seriously wrong and can be blamed for the misconduct. And lastly, retrenchment or redundancy. The employer is cutting down on staff or restructuring the workforce and or labor of a particular kind has changed. Secondly, then, when referring to procedural fairness, the questions that should be asked is, was there a fair procedure before the employee was dismissed? The employee must always have a fair hearing before being dismissed. In other words, the employee must always get a chance to give his or her side of the story before the employer decides on a dismissal. The employee is allowed to refer the proposed dismissal to the CCMA for conciliation.
Okay, and what are automatically unfair reasons for dismissal, Wynand?
So, the following are instances that will be regarded as automatically unfair if the employee is dismissed for one of the following reasons. Firstly, participation of the employee in a protected strike or protest action. If the employer refused or indicated an intention to refuse to do any work normally done by an employee who at the time was taking part in a strike that complies with the necessary provisions or was locked out, unless that work is necessary to prevent an actual danger to life, health, or personal safety. Furthermore, an employee's refusal to accept a demand in respect of any matter of mutual interest. A dismissal will furthermore be automatically unfair if the reason for the dismissal is the employee's pregnancy, intended pregnancy, or any other reason related to her pregnancy. A dismissal is unfair if the reason for the dismissal is that the employer unfairly discriminated against an employee, directly or indirectly, on any arbitrary ground, including, amongst others, sex, race, ethnic or social origin, culture, and language. And then furthermore, a dismissal is automatically unfair if the employee is dismissed in breach of the Protected Disclosures Act. In other words, if the employee is dismissed on the basis of having made a protected disclosure as defined in such act. A dismissal is then lastly automatically unfair if the reason for the dismissal is that the employee took action or intended to take action against the employer by exercising any right as conferred by the Labour Relations Act or participating in any proceedings in terms of the same act.
Wynand, the next one is a question very often asked. What are my rights if I was in fact unfairly dismissed?
So if a dispute concerns the unfair dismissal of an employee for reasons related to capacity of conduct, or the employee alleges constructive dismissal or does not know the reasons for his or her dismissal, the CCMA must arbitrate the dispute at the request of the employee. An employee or a duly authorized representative must complete and lodge a CCMA form within 90 days of the date on which the certificate that the dispute remains unresolved after conciliation is issued. A second leg is if the dispute concerns a dismissal for reasons that is automatically unfair, as mentioned earlier, or if the reasons for the dismissal is a reason related to the employer's operational requirements, the dispute must be referred to the Labour Court for adjudication within 90 days of the date of the certificate of outcome issued by the Commissioner of the CCMA.
Okay, and our final question for today's legal talk. What are one's remedies for unfair dismissal?
So if it is found that an employee has been unfairly dismissed, there are three possible remedies that an arbitrator of the Labour Court is empowered to award in terms of Section 193, subsection 1 of the Labour Relations Act. These being the reinstatement from any date not earlier than the date of dismissal. Secondly, re-employment in either the same work or into another reasonably suitable work from any date not earlier than the date of the dismissal. Or lastly, compensation. Reinstatement and re-employment are considered to be the primary remedies. An unfairly dismissed employee is entitled to an award of reinstatement or re-employment unless the circumstances surrounding dismissal are such that a continued employment relationship would be impractical and intolerable. Secondly, if it is not reasonably practical for the employer to reinstate the employee does not wish to be reinstated or reemployed. And lastly, the dismissal is unfair only because the employer did not follow a fair procedure.
And that's unfair dismissal in 10 minutes in a nutshell. Thank you so much, Wynand. A very interesting topic again for this week. And Wynand, of course, is from Hahn & Hahn Attorneys. Thanks so much for your time, Wynand.
Thanks, Ian.
Are you or your business in trouble and struggling to find a solution? Call Hahn & Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn & Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn & Hahn Attorneys, Wednesday mornings at 10 on eRadio.